Good morning, Kinaway members, and welcome back to another episode of Kinaway TV. Just like to apologise this morning. We've had a few technical difficulties, but you may have noticed the new countdown timer that we have on our webinar. So we're really working on the production side of things here at Kinaway TV. I'd like to start off the morning's webinar by acknowledging the traditional owners of the land on which we're all meeting and pay respects to elders past, present and emerging. Before I introduce today's guest, I'd like to remind today's viewers of the support services currently available to access through Kinaway. The first being the Business Tax Support Package. This support package helps provide access to a range of bookkeeping and accounting services, preparation and submission of tax returns and BAS statements, online access to Xero and MyOb, tax and payroll obligations and superannuation, and work cover obligations to staff. If you feel this may be of use, please jump onto the Kinaway website and fill out an expression of interest. Another specialist support service which has been recently announced and will be delivered soon is support for our member businesses around digital capability, whether it be website development, e-commerce capabilities, social media and marketing, and many other components surrounding a business and its digital presence. So please keep an eye out for this as well. Additional to the above packages currently on offer through Kinaway, we're proud to share, and in collaboration with this Friday's guest, Mervyn from Claystone Marketing, free access to Claystone's media and marketing course. The course provides an overview of social media marketing strategies and tools, which helps highlight marketing opportunities for Indigenous businesses. It's a great resource and is really helpful to businesses looking to really solidify their online presence. Another support service I'd like to mention is the confidential phone crisis line for Victorian Aboriginal and Torres Strait Islander people, launched by the Victorian Aboriginal Health Service. The service is for Indigenous people and families who feel they may need to have a yarn with someone about their wellbeing. This 1-800 helpline is a statewide social and emotional wellbeing service. The helpline, whose number is 1-800 95 9563, will operate 7 days a week from 12 p.m. to 10 p.m. You'll find their contact information on the screen throughout today's webinar. And of course, the team here at Kinaway are working hard to be present for our members. So keep an eye out as we look to host more webinars revolving around mental health and wellbeing and business and personal development. There's plenty of webinars on these topics already available on our Facebook and YouTube channels. So please feel free to jump on at any stage and make yourself familiar with the content available. Along with the webinars and support packages mentioned, Kinaway are still offering the usual forms of business support for our members. So if you feel you may need any assistance or any support, please feel free to get in contact with the team here at Kinaway. For this morning's webinar, we're pleased to welcome Matthew Karakalakis from AMK Law. Matthew is a commercial lawyer and founder of AMK Law, a multi-award winning boutique law practice strongly regarded in commercial, dispute resolution and litigation. Matthew's Aboriginal family heritage is from Narunga, York Peninsula in South Australia, born and raised on the Corner lands. As a commercial lawyer and founder of AMK Law, he has helped more than hundreds of clients with businesses in all stages of the business life cycle. Prior to commencing AMK Law, Matthew gained a top-tier law firm experience as well as government experience after commencing his career at the Australian Securities and Investments Commission. Touching on Matthew's career achievements, I should also add that he's a deadly jiu-jitsu competitor as well. We're extremely excited to have Matthew both for this morning's webinar and next Wednesday mornings as well. For this morning, Matthew will be giving participants an understanding of intellectual property law, along with an idea about how to both protect and enforce your intellectual property, and to help those who want to know more where to go for more information. This morning, Matt will be touching on topics such as what is intellectual property, the different kinds of intellectual property, and protecting and enforcing your intellectual property rights. If you have any questions throughout, please post them to either Kinaway's Facebook or YouTube channels, as we will have some time after the presentation for Matty to answer any questions. So without taking up too much more of your time, I'd like to welcome Matt to today's webinar. We hope you all enjoy. And don't forget to leave a like, comment, subscribe, and turn on the notifications for Kinaway updates.
Thanks for that deadly introduction, James. And I also would like to give an acknowledgement to the traditional owners of the land in which we're in today, and pay our respects to our Indigenous elders, past, present, and future. So James has given a good introduction, and one of the great things about Kinaway is that we get to know each other as members, and we've got a brilliant community. So I think that a lot of you know me already, and I'm lucky enough to know a lot of you guys as well. I've spent more than 15 years working as a lawyer, and I've worked across a range of commercial matters, dispute resolution, litigation, and I've done a lot of work in the intellectual property space as well. So what I really want to be able to do today is make sure that we have a really enjoyable presentation, enjoyable webinar. I want you guys to feel free to chuck in the chat box any question that might come up as we go through. I want to try and address each of those questions. There's going to be a question come at the end as well, so I'm happy to take questions there. And I hope that you really enjoy today's presentation. The objectives of today. The objectives of today are to give you an understanding of intellectual property law, so that you can understand exactly what your intellectual property law rights are, and also how can you protect and enforce your intellectual property rights. I want you guys to be in the position where you know where to go for more help if you need it, and also so you can have an understanding about what exactly your intellectual property law is, what those rights are, and so that you can really be able to appreciate the valuable assets in which your intellectual property really is. So first up, what you would really, I think, appreciate in knowing is what is intellectual property. You hear this word bandied around, IP, intellectual property, and these kind of things. And what's interesting is a lot of people don't really understand exactly what is meant by intellectual property. So intellectual property is the property, this is actually from the IP Australia website. Intellectual property is the property of your mind or proprietary knowledge. Basically, the productive new ideas you create. It can be an invention, trademark, design, brand, or the application of your ideas. In Australia, IP rights are protected under Commonwealth legislation as well as by common law. Common law is really the cases, so decisions that are made by judges, which is another form of making laws, rather than through legislation that's passed by Parliament. Intellectual property law also comes from other legal principles, regulations, and contractual rights. We're going to go into some of the contractual rights soon or later in this presentation. And I think a good thing to know about contractual rights is one of those things that you guys as business owners can actually take active steps in enabling your intellectual property to be protected by a contract. So intellectual property comes from your business ideas, your creative efforts, and it is valuable. And your intellectual property can be created in a variety of ways. So for example, when you are out there setting up your business, designing and establishing your website, in your advertisements and marketing ideas, the business name, logos, everything that you actually create that is of artistic works in your business is extremely important, valuable, and is intellectual property. Let me share this quote with you guys. In preparing for today's presentation, I came across this quote, and I think it really does help in understanding what intellectual property is and why it's valuable. So this is from James Boyle, from the public domain and closing the commons of the mind, who said, "At the moment, everyone gets a copyright as soon as the work is written down or otherwise fixed, whether they want one or not." So we're going to go into copyright in a moment, not yet, but what's really important in that, as expressed in this quote, is that as soon as you create something, whether it be written works or artistic works, copyright automatically comes about to protect you. Then we look at the quote, Kalian C. Cancanala, who said, true inventors do not sit on their inventions. And I wanted to share that quote with you because it's important for you to remember that active steps need to be taken, and we're going to be covering in today's presentation what specifically you can do to make sure that your intellectual property rights and your inventions are truly protected. Got a question coming through asking, is IP protection one of the first things we should consider when starting a business? And the answer on that is most definitely. You do need to make sure that you are considering your intellectual property as one of the very first things you consider when starting your business. So if you look at the business itself, in setting up your processes, your systems, your goodwill, all those things that actually comprise your business, your client databases, all those things are comprised of intellectual property components, and yes, you need to make sure you protect those. So going into a bit more about that as we progress in the slide as well, as we progress in the presentation as well. So the kinds of intellectual property. Patents. Patents are essentially the intellectual property rights that are applicable for inventions and innovative ideas and concepts. You've got trademarks. I'm pretty sure most of you guys would have heard of trademarks, because I think trademarks are one of the most common forms of intellectual property that we hear of, and also one of the most common forms of intellectual property that people want to start looking at when setting up their business. Trademarks themselves are the intellectual property belonging to a word, phrase, logo, or sound, and can also go to the intellectual property and even a smell, a shape, a picture, or any combination of these. So actually what's covered by trademark is wide, can't you see? And so another form of intellectual property is designs. So designs, that's the intellectual property that comes up when you've got the design of a particular shape, pattern, framework, configuration, product. That's about the design. Then we look at copyright. Copyright is the actual original form of an expression itself. So copyright doesn't just come about by an idea. An important thing to remember with copyright is that it actually has to come from the creation in work from an author or artist's effort. We'll look more into copyright because copyright is also a very common form of intellectual property, and I think you guys will benefit a lot from knowing more about it. Copyright exists in intellectual property, including literary. So these are the words that come from case, right? So literary, musical, or artistic works. That's a fairly common phrase that is in a lot of the case law around copyright. But essentially, as long as you've got some written context, some drama, performance, dance, music, some artistry works done by an artist, then that is copyright material. And so it is things like sound recordings, films, broadcasts. Even this recording right now has copyright in terms of the intellectual property vested in it. Another form of intellectual property is plant breeders' rights. You don't hear all that much about plant breeders' rights, but it's still something to be aware of. Plant breeders get a specific form of intellectual property, which comes about as a result of the certain varieties of plants as they're created. So the rights themselves in those plants are a form of intellectual property. And it's important to remember that to be able to get the benefit of plant breeders' rights, you need to have the variety of plant actually part of a scheme in connection with that plant. So that might be one of the reasons why you don't think too much about it, because of the scheme requirements. Another form of intellectual property is Indigenous cultural and our rights vested as Indigenous persons with intellectual property, or ICIP. ICRP is really about the legal rights that our mob has, or our mobs have, to protect the traditional art, stories, dance, language, and culture. It's really based on the concept of self-determination and is an area that must be developed further. We'll go into this a bit more in our presentation as we progress. Another form of intellectual property that's really important to understand and be aware of is confidentiality. So confidentiality is about the intellectual property in the material that you have in your business, such as client lists, databases, particular ways of going about doing things in business that needs to be protected. So let's go into a bit more detail on trademark. So as I was saying earlier, trademark is one of the most important areas of intellectual property that we see at the very beginning of a business cycle. Trademark is user intended to be used to distinguish goods or services that are dealt with or provided in the course of trade or commerce when providing goods or services. This is really a paraphrase of Section 17 of the Trademarks Act, which is Commonwealth legislation. See, trademark can come about by common law, legislation, exactly as I was speaking about before. So if somebody goes out there and makes an almost identical copy of, say, a symbol, then that's a breach of trademark. Or if somebody uses a word that is pretty much the same as another company and they can be confused with that company, for example, because they provide similar goods or services, that as well can be a breach of trademark. So an example of that is just say you had a company come out there and they create this red coloured cola drink. I think based on that everyone already knows what I'm talking about. But if you have this red coloured cola drink that's called Smoker Smola, well, obviously that's a breach of trademark amongst other breaches. But the point being is the name Coca-Cola would be breached in terms of its trademark, potentially the packaging because there's similar colours. And so that's an example of understanding where trademarks can apply. Be careful of those in your own business and what you do in terms of not breaching other people's trademark rights, and also in terms of ensuring that your trademark rights are properly protected. So at common law, there's a case, a pretty famous case called Mantra Group, Pty Ltd and Tally. This case is pretty popular in terms of intellectual property law. And this case said that to establish a common law trademark, you need to show that a trademark's been used, for example, as a brand name or an advertising, to such an extent that it has become recognisable as distinguishing the business or its goods and services from those of others. So what's really valuable in understanding about that is that, remember earlier I was speaking about how you can have trademarks that come about through case law as well as legislation. Well, this case is what you got to look at when understanding the trademark rights that come from the cases. The cases, the courts, they look at how long has that particular trademark been used. Has that trademark been used as a brand name in advertising? Has that trademark been used so much that it's really distinguishable as being part of your business? And some factors that a court will look at is things like how many times have you used that branding, how long have you used it for, how integral a component to your business is it? There's a number of factors there. Now, to protect your trademark, the best way to do that is to apply for registration. Section 27 of the Trademarks Act, which is Commonwealth legislation from 1995, sets out the need for registration in terms of being able to get the benefit of the legislation protection. And also, you can understand that the Trademarks Act also allows for companies. So just say you've got your business set up as a company, your company itself can register that trademark. The registration process is quite a efficient process. The trademark process is also set out on the IP Australia website. I encourage everyone who's interested in intellectual property to check out the IP Australia website because, in my experience across a variety of government departments, IP Australia, in my view, is probably the most helpful government department. If you speak with somebody from IP Australia on the telephone, you probably call them and get, almost put through straight away. The website's got great information, so it's really, really useful and a great resource to have in terms of that IP Australia website. But essentially, the process that's set out on that website to register your trademark is governed by the Trademark Act. And what needs to happen is you need to apply to the registrar through the IP Australia website. At any stage of the application, a rejection or non-approval could occur until you've actually got that final approval. But essentially, what you do is you need to go through and make sure that if you want to register a trademark, you've actually got a true right to that trademark, that it's not identical to any existing trademark, otherwise your application will be refused. You need to make sure you've given all the information to support your application so that the registrar can examine and approve the trademark. Then what happens is after the registration is put through and after it's been examined, if your trademark's been accepted, then an advertisement goes out to the public and other people have the opportunity to oppose that trademark. So other people can say, look, I've got a common law right. Remember I was speaking before about use of that trademark in the branding and things like that. If somebody could step up and say, hey, look, this trademark shouldn't be registered because I've got this common law right. At that point there, IP Australia, through its registration process, will have its allocated registrar look at that objection and then make a decision about whether or not the grounds for that rejection are honoured or not. Also, what will normally happen is there'll be a process where grounds can be submitted to support that objection. Then you can respond to that, and there's a dispute resolution process that takes place. The tip there is, if things start getting tricky in that regard, you really are best to have a lawyer prepare documents for you about those kind of things, because the way that you put your documents forward, the submissions that need to be made can get quite complex if there's an objection. But the truth be said, I've personally had a few instances where we've dealt with objections, but normally, if you go through the trademark application process, normally approval is quite straightforward without problems. But remember, problems can arise. So once the trademark's registered, then what happens is the owner of the trademark has the right to exclusively use the brand name, and the trademark itself can be licensed out. The trademark itself is an actual asset in the goodwill of the brand, and that's actually, again, properly set out as a legal right by Section 21 of the Trademarks Act. So this is another example as to what I was saying before about your intellectual property being really important and valuable in the business. Legislation recognised that the asset that's created by a trademark is actual goodwill in your brand and in your business. There's some cases that also recognise the rights once it's been registered. If anyone wants some further reading, there's a case, Colorado Group and Strand Bags, two famous brands you might have heard of. This is a 2007 decision from the federal court. So that's probably a good one if you're interested in this area. Another case is Aston and Harlem Manufacturing. But I think Colorado Strand Bags is probably my preferred case. So I hope that's helped in terms of trademarks. Let's step forward into the space of copyright. So you guys remember what I was saying before about copyright, yeah? Copyright is the right to reproduce and the related rights of an original expression of an idea. There's those words again, expression of an idea. The whole purpose behind copyright is to encourage the creation of artistic works and works of copyright material. There's legislation that governs copyright, and that's set out by the Copyright Act, which is Commonwealth legislation from 1968, but also copyright automatically vests once the legal requirements have been met in terms of the works that's been created. I'd love to be able to share with you this case example about copyright. This case is Pacific Film Laboratories and the Federal Commission of Taxation. This is a 1970 case, so actually before I was born and probably before some of you guys were born as well. But the point is, in this case, is Pacific Film Laboratories objected to a tax assessment on the basis that the company didn't have any copyright and therefore shouldn't be taxed. So they were saying, look, there's no copyright in this asset that I'm being taxed on because there's no actual intellectual property and therefore tax shouldn't apply. Well, the High Court said rights of property right are an object in which copyright is embodied, and copyright, this is really important, copyright is not a right in a physical thing. So there can be a split of ownership of the copyright intellectual property from the object in which it's created. So what does that really mean? What it means is, just say you've got, in this instance, you had an asset. You might have something like a ship. And on that ship, there's some fantastic Indigenous art. Well, that Indigenous art is the subject of copyright, and the asset in that artist's work itself is intellectual property, and that intellectual property is capable of being owned and taxed, even though that ship in this example is not subject to copyright. So can you see the actual intellectual property can be separated from a ship, property or asset in which the intellectual property is based on. So I think that's a really good principle to think about in terms of copyright. So copyright doesn't come from a mere idea. What does that mean? And a lot of the cases talk about mere idea. What it means is you need to keep in mind the distinction between the idea and the expression. So just because you have an idea doesn't give right to copyright. So merely copying somebody's idea doesn't cause a breach of copyright. What you need to understand and consider when looking at a breach of copyright is whether there's been substance. That's a bit of a tricky word, substance. I want to go a little bit more into that in a moment, but not yet. I just want to make sure you understand the other factors to consider for breach of copyright. Because you also have to have the right to enforce ownership of that copyright. You have to be able to show that there's been an infringement of copyright to be able to prove breach, and there's some defences that can apply law. So, substance, what does that mean? Substance is really about the conditions that need to be satisfied as follows. There needs to be some works or subject matter to which the copyright relates. That's a pretty broad component, subject matter, but there has to be something there. It has to be original, has to be in some sort of material form. That goes to the point I was saying a moment ago about not being just an idea, and there has to be a connection in Australia. These requirements are set out in the Copyright Act and actual legislation requirements. So these are some key points on copyright. Copyright can be actually a fairly complex area, but I feel like you guys probably at least have some understanding about where copyright can come up and some understanding about what copyright's all about. So let's look now at cultural intellectual property. Cultural intellectual property really comes from the thousands of years in which our Indigenous cultures have been established, and our intellectual property has been used and shared in connection with our cultural knowledge, stories, artworks, dance, expressions, methods, and our very being and core of identity. I'm going to refer to cultural intellectual property as ICIP. And there's many forms in which it can come about. So some of the things that come about in some of the forms include writing, performances, if there's things like a song or some sort of music, languages, paintings, things like sacred stuff, burial grounds. There can be stories that are passed through the dream time in terms of oral communications. There can be documentation about, reports, recordings, plus more. So it's quite broad. So what's the issue here? Well, the issue here comes in a massive way because in Australian intellectual property laws don't really cover ICRP because our Australian laws don't recognise the rights of community. So our law has fallen short in terms of ICRP, and our law doesn't protect things like the underlying idea or the information. So, for example, the story behind a painting. That goes, remember I was talking before about copyright? It has to be actually more than a mere idea. There's been instances where the underlying idea or information that's been put into our ICRP has not been found to be any more than a mere idea. There's other issues about performances which haven't been recorded or written down, so they properly can't be identified in a way that can properly attribute intellectual property rights. So there's other shortfalls as well, but that's just some of the common examples. Some of the limitations are about our Australian law not actually being there to protect our Indigenous peoples and our mob rights from being exploited, misappropriated, and there has been a lot of downfall in terms of the inability to actually collect and record the ICRP. So one thing that can be done is, Aboriginal corporations or corporate entities could perhaps, as some type of interim solution, become registered and then register in a formidable way the intellectual property that's vested in the ICRP. But there's a lot of shortfalls, a lot of problems even with that approach. I am aware of some of the United Nations steps that have been taken in terms of being able to protect Indigenous people's intellectual property across the globe in some kinds of declarations and statements. But this is a really an area where there's much more work that's needed to ensure proper protection. I want to cover a point of interest for everyone, the battle about the Aboriginal flag. So some of you guys might have heard about the claims that were made about the Aboriginal flag and the private company WAM Clothing. WAM Clothing controls the right to reproduce the Aboriginal flag. And that really comes through the rights that were given by Harold Holt. And a question that I ask you guys is, how can a person or private company own the rights to a national symbol and everything it represents for Indigenous rights and Indigenous people? So obviously there's a moral and a First Nations people's rights perspective in answering and considering that question. I ask you, based on what we've already discussed, and if we just keep our black and white, unemotive legal hat on for a moment, from a pure legal standpoint, based on what we've discussed, can anyone see or understand how the rights in a national symbol, as in our Aboriginal flag, can actually be owned at law? If anyone's got any thoughts or wants to take a guess on that answer, feel free to check that down in the chat box and we'll cover that at the end as well. So it's really important to protect your intellectual property rights. You need to remember to protect those rights. You need to remember to get advice if you don't understand what those rights are. Your intellectual property is extremely valuable, and there's a number of ways in which your intellectual property can be protected. So there's legal protections, there's the registration requirements that we've covered, there's the common law rights that we've covered, and another key component is having legal agreements in place. And so you can look at the IP Australia website for more information. And the other thing you can check out is we have a product called Boost Legal Templates that I've been working on in terms of some of the legal requirements set out there, and some other top tier lawyers have also been working on Boost Legal Templates. It's a product that we have available online, and if you visit the Boost Legal Templates website today, you can discover some of the great IP contracts and agreements that we've got in place to protect your intellectual property. So, for example, we've got intellectual property license agreements so that you can actually generate income by licensing your intellectual property. We've got intellectual property assignment deeds that set out how the ownership can be passed across. We've got non-disclosure agreements that protect your confidential information. So just say you're sort of sitting out there and having some initial discussions about partnering with someone or providing some products or entering into a great contract with an organisation. An NDA, which is the shorthand for non-disclosure agreement, can protect you in those circumstances. We also have service agreements and contractor agreements that have IP clauses and confidentiality clauses. So check that out and stay tuned, because we will be announcing a great partnership with Kinaway to help you guys as Aboriginal businesses in terms of being able to get those legal contracts through Boost legal templates in a really exciting announcement to be made pretty soon, I think. What can you do if your intellectual property rights are infringed? Well, there's some real common remedies for infringement of intellectual property rights. They include injunction, damages, account of profits. There are others as well, but they're the most common in my experience. Let me tell you a little bit about these. So an injunction is you get a specific order which can be made on an urgent basis from the court that prevents another company or another person from breaching your intellectual property rights. Damages, I reckon a lot of you guys probably already know what damages are, but let me explain it anyway. It's being compensated for any loss that you've suffered as a result of somebody else taking advantage and effectively stealing the intellectual property that you own. And another common remedy is the account of profits. So an account of profits is, just say you've created a fantastic t-shirt, you've got trademark intellectual property in terms of what's on that t-shirt, the words that are used in the t-shirt, and then somebody else goes and rips that off, creates an almost identical t-shirt with the same words, and makes a ton of profit from that. Well, that profit itself could be paid back to you as an account of profit. So that's the intellectual property 101. And I really hope that this has helped with your understanding of intellectual property laws. And I hope that you've got some understanding now about how you can protect your intellectual property and your rights with respect to intellectual property, both from a cultural perspective, as an Aboriginal business, as an individual, and also so that you can really see the value in your intellectual property and see that as a valuable business asset so that it can be profited from, used appropriately, and you can progress in your business with the safety that you need and the protections are in place for you and your business. I noticed some questions or comments come through earlier saying that the slides here are a little bit small, but I'm happy to share these slides around with anyone that might be interested. And as a final closing quote, Albert Einstein said, "Try not to become a man or woman of success. Rather, become a man or woman of value." And that's really what intellectual property is about, the value. Thank you very much.
Wonderful. Thanks, Matty. Thanks for joining us this morning. Some really helpful information for all our members. And yeah, I'd encourage anyone that tuned in to jump onto that Boost Legal templates and check out some of the resources there, which makes it maybe really useful to our members. I know while you were presenting, we had plenty of questions come through, so we might take the next 5 to 10 minutes just to go through a few of these questions, if you like, and address them for our members. So the first one is from Katie, and she asks, "Hi Matt, thanks for today. I'm looking to deliver webinars and workshops online, and I'm wondering if I need to include the copyright symbol throughout the presentation."
So copyright itself exists as a right, so long as those requirements have been met that we're speaking about. You don't need to include the copyright symbol, but you are best to include the copyright symbol just to show that there's an assertion of your legal rights. But just because you don't put the copyright symbol there doesn't mean that you don't have the rights. Hope that answer helps.
Wonderful. The next one is from Mike. If I don't use my trademark, from what I understand, it can be removed for non-use. What is the time frame for that to happen?
So, excellent question, Mike. And I also appreciate the fact you're speaking about trademarks here, because it's good to understand the usage component for trademarks. So, there's a couple of contingencies that can fit the answer to the question. So, the first contingency is whether or not your trademark is a registered trademark or whether it's a common law trademark. If it's a registered trademark and you haven't used that trademark, it's okay. You just got to make sure that you keep your registration in place. So keep through so what happens is when you register your trademark, you register and there's a renewal period. So I think you can register for either 5 or 10 years or 5, 7 and 10 years. You choose your option. You need to make sure that you've renewed your registration of that trademark with IP Australia before that expiration. If you've done that, even if you don't use the trademark, you're all good. If your trademark is solely a common law, remember those factors I was speaking about earlier? So if you haven't used your trademark at common law, then your rights can be seriously affected. So it really is best to always ensure that you've got a registered trademark so you can actually point to something and say, hey, this is mine.
Wonderful. That helps, Mike. Next one is from Taylor. They ask, thanks, Matty. Is it hard to prove when you feel your trademark is breached, like when another business has a similar style of logo, and what's the process?
Yeah, so as long as it's normally not very hard to prove, because normally if there's a breach of trademark, it means that there's been another business or organisation that's gone out there and tried to sell or brand different products or content on their website or portray to the public that they've got this particular branding in place, and those sort of things can form evidence. So as long as you can capture that material, then it's a matter of really our best sending a legal letter of demanding that the breach of that trademark and intellectual property right that you have cease. And at that point there, you can also demand some of those remedies I was speaking about. Remember those things like damages, account of profits. You can also, in that sort of communication, have in black and white the notice requirements sent out saying you're going to seek an injunction. And then if that isn't complied with, you can step forward through that legal process.
Sure.
Hope that helps.
Next one is from Douglas. And he asks, how can I check if my trademark is similar to others?
Yeah, so one of the things is if you jump on IP Australia's website, there's a search function called Atmos. So it's pretty easy to find. If you go to the IP Australia website, you'll see there's a trademark section. Click on that one, do the Atmos search, and then you can put in there, if it's a word, for example, you can put in the word that you want to see if it's trademark, or you can search different images in different categories. It's way easier for the word, but otherwise you can still see if there's a registration that's similar to others. If other people have got the common law trademark, it's actually much harder to see. That's just going to come down to market research. So yeah, this is another reason why registering a trademark is way better to protect your intellectual property.
Sure. Lovely. The next one is from Steph, and she asked, thanks for this morning's webinar, Matthew. If I have a trademark, do I have to monitor the marketplace for any potential infringements? Can I get help doing this?
Steph, thanks for attending the webinar this morning, and thank you very much for your question. So you should ensure that there aren't any infringements of your trademark. I actually had a matter recently where a client was really proud they'd actually gone out there and they had registered their trademark for their branding, and then found out that a company was branding with the exact word that they had trademarked. And they were asking me, is that an important infringement? I said, look, just say you owned a property and someone was stepping on your property and using your property, like a house that you owned, they were using there, they might be squatting there, not paying you any rent at all. Wouldn't that peeve you off? And it would, right? exactly the same thing with intellectual property. Intellectual property is a very, very important asset, and you need to make sure people aren't infringing that asset. Ways of doing that include being aware of what competitors are doing. Sometimes you can find out about infringements as simple as typing in some particular keywords into Google, doing an online search, and there are some agencies that can help you with those kind of things as well.
Lovely. Hope that helps, Steph. The next one is from Nicole Harding, and she asks, legally, he has the right as he owns the copyright. I'm assuming this is in reference to the flag we were speaking about, and this was proven supposedly in the High Court. What doesn't make sense is how a government/governor can appoint a flag as representing a people that has this type of copyright around it. I think it's the only flag in the world that has this.
Yes, and I'm just sort of looking at this. This is pretty deadly point that's being made. I'm just trying to make sure that I understand the question. But yes, Harold Holt owns the right through the copyright. I'm not sure exactly where this is all at the moment. I haven't heard anything about sort of where it's currently at over the last few months, so I'm not really sure exactly what's happened. I think there's a settlement that's been achieved somewhere. And I think that it also doesn't make sense about how a person can own something that's integral to our mob across the country. And I think that this is also tied in terms of the downfall and shortage of the ICIP that we're speaking about. And I think this is an area in which there must be drastic improvement, because there's a lot of identity that's associated with our Aboriginal flag. And so I don't think it's right for one individual to be able to own that intellectual property and then also to be able to license that out. So there's a lot of problems there for sure.
Absolutely. Thanks, mate. And this is the last one, the last question that's come through. It's from Douglas again, and he asks, are there any sorts of situations I should use trade secrets to stop proprietary knowledge away from competitors? How do I protect trade secrets?
Adam, can you just ask that one again? Just want to make sure that I've understood the question properly.
Wonderful. It should pop up soon. We have had a few technical difficulties this morning, but this one's from Douglas, and he asks, are there any sorts of situations I should use trade secrets to stop proprietary knowledge away from competitors? How do I protect trade secrets?
I understand. Deadly question. So trade secrets are generally covered by confidential information, right? So it depends on how, where, and why you want to protect that information from competitors, and it also comes down to how the competitors find out about the information. The short answer is, in terms of trade secrets and confidential information, make sure that you have legal documents that are A1 spot on, which is why I was speaking about Boost Legal Templates. Non-disclosure agreements can help you in terms of any discussions you might be having in terms of any opportunities through your business. So check out the NDA on our Boost Legal Templates website. Contractor agreements can protect you and your business from any information that contractors might get a handle of. Because, for example, someone can go out there, help you out as a contractor, get all your trade secrets, and then ruin your business. Service agreements can protect you in a similar way. So just check out what's on Boost Legal Templates, and I think that'll help you a lot in that area.
Perfect. Well, Matty, I think that's it for questions today and for the webinar. So on behalf of Kinaway and also everyone that tuned in today, I just want to thank you for joining us.
Thanks, brother. It's been a pleasure to be here.
You're welcome. And I'd like to thank everyone who tuned in for this morning's webinar. Before we go, I just want to remind everyone we're back on Friday morning with Merv and Fernando for part 2 of Claystone Marketing's presentations, where Merv will be presenting on the benefits of Facebook marketing and best practice for increasing engagement on the platform. We will also have Matty back next Wednesday as he touches on how crucial it is for a business to have the right business structure and how each structure may have an effect on key business functions and viability. Once again, I'd like to thank both Matt and everyone who tuned in this morning for the webinar. And we look forward to your joining us on Friday. And as always, please leave a like, subscribe, and turn on the notifications. And we hope you have a good Wednesday. A few more technical difficulties. It should close soon. So yeah, see everybody on Friday.